The annual Sovereignty Symposium, it was held this week online. It was a virtual event. The symposium organizers say it represents an opportunity to provide a forum to discuss common legal issues in a non-adversarial environment. But that was not always the case this year. Taylor Jackson joins us now to tell us what was discussed. Taylor?
Rich, not surprisingly, the McGirt decision was a prime topic of conversation. The state administration is hoping to overturn it in court. Tribal leaders say that cannot happen and proves once again that their sovereignty is being threatened.
The protection of sovereignty has become a major sticking point between the state of Oklahoma and the tribal nations, which have reestablished their criminal justice system under the McGirt decision.
We do have to be vigilant because there are plenty of enemies of sovereignty out there. One of them is the Attorney General of the state of Oklahoma, who wants McGirt overturned. The other one is the governor of the state of Oklahoma, who wants McGirt overturned.
There's nobody that's anti-sovereignty. I've not talked to one person who I would consider to be an enemy of sovereignty.
Cherokee Nation Principal Chief Chuck Hoskin Jr. says Stitt and his appointed state attorney general John O'Connor want to convince the country that the tribal nations cannot handle the responsibility of creating a successful criminal justice system.
I think the opposite is true. Not only can we be trusted, I think we're doing it better than many states, and I think we're going to create a great criminal justice system. I think that if you look at what we're doing across the board in public policy, we're doing it better.
Ryan Leonard is the special counsel to Governor Stitt for Tribal Affairs. He says tribes and the federal government are attempting to apply the McGirt decision beyond their criminal justice systems.
We now have the Department of the Interior, who has taken it upon itself to strip the state of its regulatory authority over the mining program based upon an expanded reading of McGirt. We've had wind that other federal agencies aren't far behind.
Governor Stitt has filed suit against the Department of Interior for what he claims strips Oklahoma of its jurisdiction to regulate mining, something Leonard contends is necessary to keep McGirt from being applied to non-criminal jurisdiction.
The McGirt decision very explicitly says that this decision is limited in scope to the federal major crimes. Didn't say anything about civil jurisdiction. However, there are those amongst the tribal communities and our partners and friends in the tribal leadership, as well as now the federal government itself, who've used McGirt much more broadly as applying not only to criminal jurisdiction, but also to civil jurisdiction.
The Supreme Court left all other questions about how we move forward as a state for courts, Oklahomans, and our native nations to figure out, piece by piece, sometimes struggle by struggle, for years and probably decades to come.
The state solicitor general argued the McGirt case before the U.S. Supreme Court. He contends McGirt leaves many aspects of law enforcement open for interpretation, like traffic tickets or other ordinance passed by cities within a native reservation.
Other questions revolve around municipal court jurisdiction over crimes and infractions under the Curtis Act, which was enacted in 1898 and gave municipalities in the Indian Territory explicitly jurisdiction over Indians.
Even as the state and the tribes are in a virtual standoff over the McGirt decision, the U.S. attorneys for the northern and eastern districts of Oklahoma have taken on additional work of prosecuting crimes that just over a year and a half ago were rare in federal court.
This is a unique moment because there is no doubt that the responsibilities that come with the McGirt decision, the drain on resources, are significant.
In fact, the current U.S. attorneys have asked for and received additional funding and shared resources with other federal prosecutors as they take on the increased caseload in Indian country.
This is not an option that the United States government has, but rather an affirmative obligation. We see it captured in treaties, in law, in judicial decisions, and time and again the United States has failed. And time and again, the United States has succeeded.
With over 370 treaties between Native tribes in the United States, Muskogee Nation Principal Chief David Hill says the government must uphold their promises.
Our ability to collectively live as sovereign nation absolutely requires the federal government to honor these treaties and respect the rule of the law. Allowing them to violate these treaties at will threatens the very existence of every tribe in the nation.
The state solicitor general says Oklahoma will continue to pursue limitations on McGirt, but there are opportunities to work with the tribes.
The AG's office looks forward to not only litigating the cases when we have to litigate, but also working with our tribal partners when the need for litigation isn't as strong.
Many of the tribal leaders agree the state, the federal government, and the tribes can find a way to work together.
Together, we have the tools we need to address the challenges of serving every individual who calls this area home.
Coming up later in this newscast, we will have an in-depth discussion on Oklahoma's efforts to improve results in finding missing Indigenous women and children.